We have a warrant to search this property. Step aside.
Then present it.
We're executing a lawful search.
Under the Fourth Amendment, you must show the warrant before entry.
You're interfering with a police investigation.
No, I'm asking for judicial authorization.
Ma'am, don't make this harder than it needs to be.
Show the warrant.
We don't have it on us. Step aside now or you're being detained.
What you just heard wasn't a misunderstanding. It was an officer attempting to enter private property without presenting a warrant and then threatening detention when asked to follow the Constitution. The woman on that porch wasn't interfering. She was asserting her Fourth Amendment rights. And the officer made a catastrophic mistake. He chose intimidation over procedure, assumption over law. What he didn't realize is that this homeowner is a sitting federal judge. Within hours, that body cam footage would trigger an internal investigation, a civil rights lawsuit, and consequences that would end a career and force the department to answer for more than just one officer's behavior. The homeowner is Judge Angela M. Carter, 58 years old. She is a sitting United States District Court judge, appointed to the federal bench 12 years ago after nearly 2 decades as a federal prosecutor. Before that, she served as an assistant U.S. attorney specializing in civil rights enforcement. Over a 30-year legal career, she argued more than 120 federal cases, supervised complex constitutional litigation, and authored dozens of published judicial opinions cited in appellate courts. She has presided over major federal trials involving corruption, organized crime, and constitutional violations, respected by peers across party lines. She has received multiple Judicial Excellence Awards and has lectured at accredited law schools on constitutional law and due process. In other words, the officer wasn't confronting a suspect. He was confronting one of the very people tasked with interpreting the Constitution he claimed to enforce. The officer on that porch is Officer Daniel R. Mercer, 34 years old, a patrol officer with the Brookdale Police Department. He had been on the force for 7 years, according to internal records later obtained through a public records request. Mercer had accumulated 9 citizen complaints during his career for alleged excessive force, 3 involved discourtesy or hostile conduct, 2 raised concerns about racial bias, none resulted in termination, 7 were ruled not sustained, 2 resulted in brief written reprimands. In one prior incident, body cam footage showed Mercer escalating a routine stop within seconds. The internal review concluded he had acted within departmental discretion. Despite the pattern, Mercer remained on active patrol. He had received no suspension longer than 2 days, no mandatory retraining beyond standard annual requirements. The department's official statement before this incident described him as an officer in good standing, institutionally protected, repeatedly cleared. Until this time, the system had absorbed every complaint. The patrol car stops directly in front of Judge Angela Carter's residence in Brookdale Heights, a quiet residential neighborhood with single-family homes and maintained lawns. It is late afternoon. Neighbors are outside. 2 are walking a dog across the street. Officer Daniel Mercer exits the driver's side. His partner remains near the vehicle. Mercer walks up the driveway without knocking first, scanning the front windows. His right hand rests near his belt. Judge Carter steps out onto her front porch after hearing the car door slam. She is holding her phone at her side. Mercer does not greet her. He does not ask if she is the homeowner. "We have a warrant to search this property. Step aside." She remains where she is. Then present it. Mercer steps closer, reducing the physical distance between them to less than 2 feet. The camera angle tilts slightly upward as he moves onto the porch. "We're executing a lawful search." She keeps her voice even. "Under the Fourth Amendment, you must show the warrant before entry." Mercer exhales sharply. He shifts his weight forward. His left hand touches his radio. "You're interfering with a police investigation." She does not move aside. "No, I'm asking for judicial authorization." At this point, Mercer's tone changes. It becomes sharper, louder. He stops referring to her as ma'am. "Don't make this harder than it needs to be." He glances briefly toward a neighbor who has stopped walking and is watching. His jaw tightens. Judge Carter stands upright, shoulders squared. "Show the warrant." Mercer pauses. "We don't have it on us." He immediately follows with, "Step aside now." There is no attempt to clarify the alleged warrant. No explanation of probable cause. No paperwork visible. No supervisor present. Instead of de-escalating, Mercer leans closer. "You match the description." She asks, "Description of what?" He does not answer. He scans her face and clothing. "This is her home. She is standing on her own porch. There is no reported disturbance at this address. No visible criminal activity. Yet Mercer continues to treat her as a suspect. Hands where I can see them. Her hands are already visible. I am the homeowner. She states, yeah, prove it. The request is not made to confirm residency. It is delivered as a challenge. Across the street, a neighbor begins recording on a phone. Mercer notices. His voice lowers, but his posture remains aggressive. You people always want to argue. There is a brief silence. Judge Carter says, repeat that. He does not repeat it. Instead, he steps even closer, forcing her to lean back slightly to maintain space. You're obstructing. I can detain you, she responds. On what charge? He does not articulate one. He reaches toward his handcuffs, but does not remove them. The gesture is visible on camera. It is a physical signal of threat. She says clearly, you are on my property, without presenting a warrant. Mercer turns partially toward his partner. She's being uncooperative. Uncooperative because she asked to see a warrant. Uncooperative because she cited the Constitution. Uncooperative because she did not immediately submit. The neighbors remain watching. No one intervenes. The imbalance is visible. Uniform, badge, weapon, raised voice on one side, a black woman alone on her porch on the other. Mercer radios dispatch. Send a supervisor. Judge Carter says, yes, please do. He paces a step down and back up the porch. The camera captures the front door behind her private residence, as if it were a target location rather than her home. There is still no warrant produced. No documentation shown. No explanation provided beyond vague claims of a report. Instead, there is repeated emphasis on authority. Last warning. Move she does not move. I would not consent to entry without a warrant. Mercer shifts his stance again, feet widening slightly. His voice lowers, but becomes more forceful. You don't want to do this. She answers, I already am. The supervisor vehicle arrives minutes later. The immediate entry attempt stops only because oversight is on scene. Up until that moment, the trajectory was clear. Escalation, intimidation, and the presumption that this black homeowner needed to justify her presence in her own house. No probable cause articulated. No warrant shown. No de-escalation attempted. Only suspicion directed at her without visible cause. And every step of it was captured on bodycam. The supervisor arrives, but does not immediately take control of the scene. Instead of asking why no warrant was presented, he first asks Mercer, what's the issue? Mercer answers quickly, she's refusing lawful entry. Being combative, Judge Carter corrects him. I asked to see the warrant. There isn't one. The supervisor looks at her, then back at Mercer. He does not ask to see documentation. He does not ask for clarification of probable cause. He accepts Mercer's framing of the situation. Across the street, a neighbor calls out. She lives there. What are you doing? Another voice. Show her the warrant. The supervisor raises a hand toward the crowd. Everyone step back. Judge Carter stands firm on the porch. There is no warrant. You cannot enter. Mercer responds louder than necessary. You're interfering with an active investigation. What investigation? She asks. No answer. Instead, Mercer steps forward and takes hold of her wrist. Turn around. She pulls back slightly. On what grounds? You are being detained. For what crime? For obstruction. There has been no physical interference, no refusal to comply with a lawful order supported by documentation, only a refusal to allow entry without a warrant. The neighbor recording says clearly, this is wrong. She hasn't done anything. Another voice, you're doing this because she's black. Mercer snaps back, stay out of it. But the pattern is already known in the neighborhood. Within days, internal records would confirm what several residents already suspected. Officer Mercer had been the subject of repeated complaints involving black residents. In one incident, he detained a black college student walking home, claiming the student matched a burglary profile. No burglary had been reported. The stop was logged as field interview. In another case, he searched a black delivery driver's vehicle after stating the driver appeared nervous. No contraband was found. The complaint was dismissed as officer discretion. The separate bias complaints had alleged that Mercer routinely used the phrase "you people" during stops involving black residents. Both complaints were ruled not sustained. Standing on her porch, Judge Carter hears Mercer say again, "You people always make this difficult. This time, it is not subtle." There is a pause. She understands. This is not about a warrant. This is not about an investigation. This is about control. Her expression changes slightly. Not fear. Recognition. She says quietly, "This is racial profiling." Mercer tightens his grip. "Turn around." The supervisor does not intervene. The neighbors continue recording. One says loudly, "She's a federal judge." Mercer responds immediately, "That doesn't matter." And in that moment, the injustice becomes undeniable. A black homeowner is being handcuffed on her own porch for asking to see a warrant. She is being labeled obstructive for asserting a constitutional right. Her professional status is dismissed. Her explanation is ignored. Her calm tone is reframed as defiance. The handcuffs close around her wrists. She states clearly, "I do not consent to this detention." Mercer guides her down the porch steps. The camera dips with the movement. The supervisor follows, but does not countermand the order. A neighbor shouts, "You wouldn't do this in that house," gesturing toward a white-owned property next door. No response. Judge Carter says one more sentence before being placed beside the patrol car. "You are detaining me because I am a black woman who did not submit." Mercer does not answer. The patrol car door opens. There is no warrant produced. No crime articulated beyond obstruction. No immediate threat to officers' safety. Only a decision, made in seconds, to treat a black homeowner as inherently suspicious, inherently non-compliant, inherently subject to force. The cameras continue recording. The neighbors do not disperse, and the department, at that moment, still stands behind the officer. The shift begins less than 24 hours later. Bodycam footage is uploaded to the department server. A supervisor flags it for review after a copy begins circulating among residents. By the next morning, the department's legal advisor requests the full file, including radio traffic, dispatch logs, and the original call report. The call that supposedly justified the search is examined first. It reads, "Suspicious person female on porch. Unknown activity. No mention of forced entry. No report of a crime in progress. No description matching a specific suspect." The address listed in the dispatch record is Judge Carter's residence. The department attorney asks, "Where's the warrant?" Silence in the conference room. A captain responds, "There was no warrant secured." Then why did the officer state there was one? No one answers. The footage is played again. Mercer's voice is heard clearly. "We have a warrant. Step aside." The legal advisor pauses the video. That statement alone creates liability. They continue. The moment where Judge Carter cites the Fourth Amendment is replayed. Her tone is calm. His tone escalates. The detention follows immediately after her refusal to allow entry without documentation. The attorney speaks plainly. "This is a wrongful detention. There is no lawful basis in the record." Internal Affairs pulls Mercer's personnel file. 9. Complaints. 2 involving allegations of racial bias. Several involving escalation without cause. Each dismissed or downgraded. The deputy chief reads from the file. Pattern of confrontational conduct during low-risk encounters. Another official response. "And we kept him on patrol." The department now faces exposure on multiple fronts. Civil rights violation under color of law. False arrest, unlawful search attempt, municipal liability for failure to supervise. The fact that the detainee is a sitting federal judge changes the jurisdictional stakes. The U.S. Attorney's Office is notified. The matter is referred to federal oversight within hours. A representative from the federal judiciary contacts the mayor's office directly. "This is not just a personnel issue," the representative states. "This is a constitutional violation involving a federal judicial officer." Behind closed doors, the mayor asks, "How did this happen?" The police chief answers carefully. "Officer discretion." The legal advisor interrupts. "No, this is policy failure. It's supervision failure." The bodycam footage continues to circulate publicly. Residents point out the language used. "You people," the aggressive tone, the absence of probable cause, the immediate assumption of wrongdoing. Community leaders request a meeting. One states plainly, "This is how black residents are treated when they assert their rights." The chief does not dispute the footage. In the department's own internal statistics, it becomes clear that Mercer stops disproportionately involve black residents. In predominantly white neighborhoods, the ratio exceeds departmental averages. The pattern had been visible, but never escalated beyond informal review. A lieutenant admits during internal questioning, "We were aware he had a confrontational style." Style, the legal advisor responds. He fabricated the existence of a warrant. The liability is now direct. The department's insurer contacts leadership regarding potential exposure. Settlement projections are discussed. Civil rights litigation under federal statute is considered likely. The chief makes a decision. Mercer is placed on immediate administrative leave pending. Investigation. His badge and service weapon are collected the same day. A formal statement is drafted. The department does not condone conduct inconsistent with constitutional protections. Behind the language, the reality is more severe. A patrol officer falsely asserted judicial authorization, attempted warrantless entry, and detained a black homeowner who was lawfully on her property. The footage shows no threat, no resistance, no criminal behavior, only escalation. The mayor's office releases a brief statement acknowledging serious concerns. Regarding procedural compliance, the federal review begins. For years, complaints had been absorbed internally. This time, the combination of body cam evidence, public visibility, and the status of the victim prevents quiet resolution. In a final internal meeting before public announcement, the deputy chief states clearly, "This is indefensible. No one disagrees. The corrective action is no longer optional. It is urgent." The investigation expands beyond Mercer's conduct to supervisory oversight, complaint handling procedures, and bias training enforcement. Policy manuals are reviewed. Training records are audited. The department is no longer managing a complaint. It is managing institutional exposure, triggered by the visible detention of a black woman who asked to see a warrant, and the record shows that she was right. Within weeks, a federal civil rights lawsuit is filed in U.S. District Court. The complaint alleges unlawful detention, attempted warrantless search, violation of the Fourth Amendment, and racial discrimination under federal civil rights statutes. It names Officer Daniel Mercer individually and the city of Brookdale under municipal liability for failure to supervise and failure to address a documented pattern of misconduct. During discovery, internal records are subpoenaed. Training logs show Mercer had completed mandatory constitutional procedure training 3 months before the incident. Supervisory review notes describe him as assertive and proactive. Despite repeated citizen complaints involving escalation with black residents, statistical analysis commissioned by the plaintiff's legal team reveals that Mercer's discretionary stops involved black residents at nearly double the department average. None of those stops resulted in felony charges. Most ended without citation. In deposition, Mercer is asked directly, "Did you have a warrant at the time you told Judge Carter you did?" "No." "Why did you say you did?" "I believe we would obtain one. You told her you had one." No answer. The city's legal counsel recognizes the exposure quickly. A trial would place body cam footage, complaint history, and racial disparity data before a federal jury. Behind closed doors, settlement negotiations begin. The final agreement totals $1.2 million. Of that amount, $750,000 is allocated for constitutional rights violation and unlawful detention. $300,000 is designated as punitive damages related to racial profiling. $150,000 covers legal fees and litigation costs. The settlement does not include a confidentiality clause regarding the body cam footage. At a press conference, a reporter asks the mayor, "Was this racial profiling?" The mayor responds carefully. The conduct was inconsistent with department values. Judge Carter's attorney answers more directly. She was detained for asserting rights in her own home. That is not complicated. Simultaneously, the Department of Justice opens a preliminary civil rights review. While no criminal charges are ultimately filed, the federal inquiry concludes that Mercer's actions constituted a willful misrepresentation of authority and an unlawful detention. Officer Mercer is terminated for dishonesty and constitutional violations. His law enforcement certification is suspended pending review by the state licensing board. Within months, the board revokes his certification permanently. During the disciplinary hearing, Mercer states, "I was doing my job." The board chair responds, "Your job does not include fabricating a warrant." The consequences extend beyond one officer. The department enters into a binding policy reform agreement with federal oversight recommendations. Changes include mandatory written verification of warrants before attempted service, body cam activation audits for all property searches, external review of citizen complaints involving allegations of racial bias, quarterly publication of stop and detention demographic data, independent civilian oversight with subpoena authority. Supervisors who previously dismissed bias complaints receive formal reprimands. For failure to escalate patterns of misconduct, the lieutenant who described Mercer's conduct as style is reassigned from patrol supervision. At a city council meeting, a resident speaks during public comment. She was treated like a suspect because she was black. That's the truth. No one in leadership contradicts that statement. The bodycam footage remains public. It shows a black homeowner asking to see a warrant and being handcuffed for it. It shows escalation without cause. It shows an officer invoking authority he did not possess. The department cannot argue ambiguity. The numbers are clear. The footage is clear. The pattern is documented. Judge Carter returns to the bench within days of the incident. She issues a written statement. The Constitution applies at my front door just as it does in a courtroom. The lawsuit forces accountability. The termination removes one officer from the force. The reforms alter departmental policy. But the central fact remains unchanged. A black woman was detained on her own property for insisting that the law be followed. The cost to the city exceeds $1 million. The cost to the officer is his career. This story is meant to generate awareness. It proves that constitutional rights only matter when they are respected in real time, not defended after the damage is done. In 2025, Black Americans were nearly 3 times more likely to be killed by police than white Americans. And 77% of black adults say they are treated less fairly by police than white people. Ask yourself, how many people are detained for asserting their rights? How many times does your obstructing really mean you didn't submit? How often is suspicion assigned before facts are verified? And how many similar encounters never make the news? If a federal judge can be handcuffed on her own porch for asking to see a warrant, what happens to people without status, without cameras, without influence? Do you know any organizations that work to protect the rights of black people in America? Legal support groups, community safety networks, civil rights coalitions? Share them in the comments. Let's support those working for justice and safety for all. Accountability begins with visibility. Change begins with pressure. Leave your thoughts below, reflect on what you just saw, and ask yourself what real reform should look like. Thank you for watching. See you in the next video.